Well, welcome, everyone. We're going to get started in just a minute. Thank you. All right, well, good morning. My name is Suzanne Monk, and I am the FTC's Chief Counsel for Intellectual Property and Deputy Director of its Office of Policy Planning. Welcome back to the fourth session of the FTC's hearings on competition and consumer protection in the 21st century, where we are discussing innovation and intellectual property policy. Before we begin the substantive program, I'm going to review a couple of administrative matters from yesterday. If you need to evacuate the building, please leave in an orderly manner through the 7th Street exit. That's the main entrance where you came in. After leaving the building, please turn left and proceed down 7th Street across East Street to the FTC Emergency Assembly Area. Please remain there until instructed to return to the building. If you've received a visitor's badge, please remember to return that. Please be advised that this event will be photographed and will be webcast and recorded with huge thanks to our amazing tech team. By participating in this event, you are agreeing that your image and anything you say or submit may be posted indefinitely at ftc.gov or one of the FTC's social media sites. We're taking public comments on these hearings. We hope that you will submit, and the deadline for public comment on this particular hearing on IP and innovation policy is December 21st. With that, it is my extreme pleasure to welcome Drew Hirschfeld from the PTO. Drew Hirschfeld is Commissioner for Patents for the U.S. Patent and Trademark Office. He was appointed to this position in July 2015. As Commissioner for Patents, Mr. Hirschfeld manages and leads the patent organization as its Chief Operating Officer. He is responsible for managing and directing all aspects of this organization, which affect administration of patent operations, examination policy, patent quality management, international patent cooperation, resources and planning, and budget and administration. I'm thrilled that we have the PTO at these hearings because we have been very lucky to have a good working relationship with PTO throughout our exploration of IP issues going back to the early 2000s and probably before that. So thank you very much, and please join me in welcoming Drew Hirschfeld.
Good morning, everyone. Thank you, Suzanne. Thank you to the FTC for having me and my colleagues here at the start or at the second day of your two-day hearing on competition and consumer protection. It's my honor and pleasure to be here, and happy to be able to share some words with you this morning before I will join on the panel very shortly. I thought this morning I would address two questions that I know are central to these hearings. One of those questions is, what is the role of intellectual property in promoting innovation? And the second question is there a role for the government in advancing or supporting innovation? So let me start with the first question, and that's what is the role of intellectual property in promoting innovation? And of course, I'm going to focus, as Commissioner for Patents, I'm going to focus on patents for my remarks, and I think we all recognize that the patent system creates incentives for inventors. You, of course, have your limited time for a monopoly where inventors can reap those incentives. It is certainly my opinion, and I know is shared by many, that those incentives are what really drive and foster innovation and hence competition that goes along with it. Of course, the patent system fosters disclosure as well, and that disclosure, what you get in return for your patent right, that disclosure helps others see your invention, and of course that also fosters competition. So I know I'm starting very basic, but what I thought I would do is give an example of an inventor who I ran into contact with on multiple occasions actually in the last 2 weeks, because I think this inventors can best speak for themselves about the benefit of intellectual property, and in particular the patent system. So the inventor I'd like to mention is Dr. Lonnie Johnson. Dr. Johnson was brought to USPTO by Director Andrei Iancu as part of a series to educate our own staff on the larger patent system and what happens after patents are issued by the examiners at the USPTO. And I found Dr. Johnson's story to be very, very illustrative of the benefits of the patent system. So let me give a little bit of his background. He is what I think you would define as the classic tinkerer. He started in high school as a student and started to make a robot out of his sister's toys. I think he used her walkie-talkie to get the antenna, and he even started a fire in his kitchen when he was working with rocket fuel to do experiments in his kitchen. And he tells a very funny story about his father not chastising him for working with the rocket fuel, but chastising him for creating a fire in the kitchen and asked him to use the rocket fuel outside. After he graduated high school, he went on to get a Bachelor of Science in Mechanical Engineering from Tuskegee University, went on at the same university to get a Master's in Nuclear Engineering and an honorary doctorate degree in science. He then proceeded to work for the Air Force and NASA's Jet Propulsion Laboratory, where he worked on space nuclear power safety, non-nuclear strategic weapons technology, and he helped develop some of the nation's most advanced technological achievements, including the Galileo mission to Jupiter, the Mars Observer Project, and the stealth bomber, to name a few. More recently, he is on his own, has created multiple companies working on advanced battery technology. So why am I talking about Dr. Johnson related to patents? The reason is because Dr. Johnson is a prime example of how the patent system has fostered his own innovation, and he was able to reap the benefits from his patents, fostering more innovation by himself, fostering the creation of companies and jobs alike. So it really is a wonderful story. He has currently issued to him over 100 patents. I know they range in technologies, including, I believe, patents on topics related to spaceflight, digital technology, and I mentioned the advanced batteries that he's working on. And his actually most famous invention is the Super Soaker, which I'm not sure if you all know what the Super Soaker is, but if you've ever seen that high-powered water gun that can really spray a huge amount of water at once, he is the inventor behind that. That Super Soaker actually was, I believe in the 90s, year after year, the top-selling or one of the top-selling toys. So he's a wonderful example of a variety of technologies ranging from high-tech to water guns, where he has been able to achieve success in what he is working on, all based on the patent system. When he was asked recently, when he was at USPTO, somebody asked him about what was key and what role did the patents play, and his response was the patents were key to his success, and particularly his own personal success, and it had a huge financial impact, enabling him to make further successes from that. So it's a wonderful story, and to me it really illustrates the tangible benefits of the patent system. And of course, if you're ever asked, does it take a rocket scientist to build a water gun? I think now we know that the answer is absolutely it does, if it's going to be the top-selling gun, water gun that there is. So anyway, that's my story about Lonnie Johnson. I think it's a wonderful story. I actually struggled because in the last 2 weeks I've run into 3 or 4 people whose stories would have been wonderful here to support the same concept, but Dr. Johnson really stands out. This brings me to my second question that I told you I would address, and is there a role for the government in advancing or supporting innovation? And I, of course, believe that the resounding answer to that is yes, there absolutely is a critical role, starting with the USPTO, whose mission is to foster innovation in and of itself. I wanted to talk today, and the remaining few minutes that I have, about some of the ways we are very focused on fostering innovation. And this, I want to share some thoughts of Director Iancu, who is in his first year at USPTO, who came in with a very laser focus on a few items. At the top of that list, in my opinion, is making sure that we have a narrative that is directed to and focused on the great benefits of the U.S. patent system and what it has done for this country and how it has advanced this country. And in my own personal opinion, what Director Iancu is acknowledging is that while there are challenges in the patent system, while it is very complex, we can address those challenges. Challenges are not new to the patent system. The challenges, of course, change as we move on. But what is most critical and foundational is to not lose sight of those wonderful inventors like Dr. Johnson, who advance technology, who create jobs, who advance our country, and really move us forward in an unmatched way. So absolutely part of our job in the federal government, and particularly at USPTO, is make sure we are educating and sharing those stories. Some other areas that we are very focused on are what we've been saying are three main priorities right now at the USPTO. These are to address some of the concerns that have been in the system to make sure that we are able to focus on those great success stories. One of those, and at the top of the list for me personally, is regarding subject matter eligibility, and I believe FTC is likely planning a hearing on that coming up, and I know USPTO is planning much in this regard. There has been recent Supreme Court case law. It has changed the landscape, so to speak, in subject matter eligibility. USPTO has been working on guidance to interject more certainty and reliability in the decisions based on what is eligible and what is not eligible, so that we can all be on a better field. So we have issued a couple memos that have come out. If you get a chance to read those memos, one is on Berkheimer and Vanda. I don't want to get too weedy here, but I thought I'd mention the names. If you get a chance to read those, I think you will see we spent a lot of time to make sure that what is in there for guidance is repeatable and puts everybody on the same understanding of what decisions will be made regarding subject matter eligibility. We're also working on new guidance. I don't know exactly when that will come out, but we are working on new guidance with this same concept in mind. Again, making sure that decisions are all understood by everybody, and there is repeatability to that, adding certainty into the system. Another area, and I believe it will be a significant topic of the panel to follow, regards the Patent Trial and Appeal Board. I'm happy to have Acting Chief Judge Scott Bullock here on the panel with us. Suffice it to say, we are taking steps to make sure we're addressing concerns that were raised for the PTAB. Of recent, there was a notice on claim construction. We've also taken steps with regard to precedental opinions to increase the transparency and improve the decision-making process in what is precedental for the PTAB, and I'm sure there will be steps on the horizon. And the last of the three that I wanted to mention, which is a central pillar of what a patent examiner does, is the patent examiner search. We are taking numerous steps to make sure that the best prior art is in front of examiners as early as possible in prosecution, so that the best decisions can be made regarding the patentability of any particular patent application that they have. Ranges of projects we're working on include an electronic system that automatically brings in prior art for the examiner based on related U.S. cases. We actually released a notice yesterday to announce the kickoff of this project. It is starting in a small way and will scale up once we work out all the details. This is an absolute win-win for not only the office but also the public, as many of the public's duty to disclose requirements are met when we already have the references. We also have put into place in recent times global dossier, which is another way to look at related foreign cases and the prior art that was in them. We are kicking off a peer search pilot at USPTO, where examiners will work together both searching a similar application as a training tool, and a couple other steps we're looking at are artificial intelligence. I think that there is a very significant future for artificial intelligence in search. We have 8,000 plus examiners. They're all searching. We can take best practices and use that to feed back into some type of artificial intelligence system to make the prior art search better. We've taken a number of steps for initial programs that I've been able to see. They're not ready for release yet, but they're certainly going in the right direction. And in September, we had a request for information for the public that was released on artificial intelligence so we can gain much more. So in any case, I know I am at the end of the time for my remarks. I wanted to share those three priorities with you, and my parting thought before we move on to the next speaker is really all of the goals that we have at PTO are to make sure we are making decisions that are transparent, and repeatable and predictable, and we believe that will add a lot of certainty into the system so people will know when their patents, how those decisions were made regarding those, and it puts them in the best position to move forward. So thank you very much again for having me here. I'm looking forward to the panel after, and have a great second day to the hearing. Thank you.
Thank you, Commissioner Hirschfeld. I echo the sentiments of my colleague Suzanne Monk that we are very happy to have both you personally join us and also to have the involvement of the PTO in our hearings this morning. I am John Dubiansky, and I'm joined by my colleague Elizabeth Gillen, and we are both attorney advisors in the Federal Trade Commission's Office of Policy Planning. The first several sessions of today's hearings, both this one and the following one on litigation in particular, are a continuation of a long history of the FTC's policy research and study regarding the patent system. As our panelists discussed yesterday, in addition to our work enforcing Section 5 of the FTC Act and the antitrust laws, the FTC has a long history of promoting innovation and competition through policy research and advocacy regarding the patent system. This dates back to sessions and a chapter in our 1996 report on competition in a high-tech global marketplace, reflecting the original Petoskey hearings, as well as subsequent reports, such as our 2003 To Promote Innovation report focusing on patent quality, and our 2011 Evolving IP Marketplace report focusing on patent notice and remedies. And those reports are just part of a broader and ongoing policy and research program regarding IP rights. Today's panel, this first session, will focus on patent quality. And as we described in the 2003 report, patent quality can reflect, for example, the fact that a poor quality patent or questionable patent is one that is likely invalid or contains claims that are likely overly broad. And today's panel in particular will focus on a number of recent developments that may inform patent quality, the most notable of which is the September 2011 passage of the American Invents Act. The American Invents Act has several provisions which may inform patent quality, such as the institution of expanded post-grant proceedings at the Patent Trial and Appeal Board, as well as the shift from a first to invent to a first to file system. And in addition to the AIA, there have been other developments, including a number of cases handed down by the Supreme Court, such as the Nautilus opinion regarding claim definiteness. So with that background, I would like to introduce our panelists today. I think we've got a great panel here assembled to discuss these issues. Going down the line, we have Commissioner Drew Hirschfeld, who's a Commissioner for Patents at the USPTO. Next to him is Professor Alan Marco, who is an Associate Professor at the School of Public Policy at Georgia Tech. And prior to joining Georgia Tech, he served as the Chief Economist at the USPTO. Next is the Honorable Scott Bullock, who is the Acting Chief Judge for the Patent Trial and Appeal Board. Next is Greg Riley, an Assistant Professor of Law at the Illinois Institute of Technology, Chicago-Kent College of Law, where he teaches patent law. Next to Greg is Sarub Vishnubhakt, who is an Associate Professor of Law at Texas A&M University. He teaches patent law. And he also holds a joint appointment as an associate professor in Texas A&M's Dwight Look College of Engineering, and he was formerly an advisor to the chief economist of the PTO. And finally, we have Professor Melissa Wasserman, who is a Charles Tilford McCormick Professor of Law at the University of Texas at Austin School of Law. Just one note, as we will have opening remarks by Professor Marco, and that will be followed by a panel discussion and questions. And during this panel, we invite the audience to submit questions. Our colleagues will distribute cards where one can write down questions, and they'll be passed up to the moderators, and we will attempt, if there's time, to answer or field several of those questions. And now I'd like to invite Professor Marco to give an opening presentation on patent quality.
Thank you. It's great to be here talking about a topic that is near and dear to my heart, patent quality. So my job here is to I just want to make some brief remarks that will hopefully set the stage for the further discussion. And time permitting, I'll talk about a couple empirical results that may also inform the discussion. So first, I'm going to claim that to understand patent quality, you really need to understand patent policy. And to understand patent policy, you need to understand patent value, what brings value to the patent. So one could argue about a lot of different features, but I want to kind of stick with these main features here. The classical economic levers where you might affect patent value are length and breadth, right? So what's the statutory term and what's the scope of the patent? Statutory terms can be affected by, the length of the patent can be affected by the statutory term itself, by maintenance fees that we may charge, by patent term extension or adjustment that you may request in different circumstances. Breadth is a little bit harder to think about how policy impacts breadth, at least in a direct way. There are statutory provisions about novelty and non-obviousness, but it's a little hard to think about how we would change that if we wanted to think, we in general want to give patents broader scope. So should we make them really non-obvious? You know, would that give them broader scope? Would that change in the statute, change anything, and change in the wording? Because the courts really influence this on a case-by-case basis. So again, from a policy perspective, it's difficult to think about how we would broaden or narrow scope in general. And of course, the scope itself is influenced by the examination process that is subject to the statutes and to the courts. Of course, if you have a patent that is long and broad, but not enforceable, it's still worth nothing, right? So if you can't enforce this thing, everyone may agree, oh yeah, that's a broad patent. It's got broad scope. Must be very valuable, except no one is going to pay you for it if you can't enforce it. So enforceability is going to consist of some things like error correction in there. If we no, well, I'll leave that for later. And then regarding each of these, we want certainty. We want certainty with respect to length, certainty with respect to breadth, certainty with respect to enforceability. And really that certainty, or really the uncertainty about those, is about patent quality, is when we think of patent quality. So I want to sort of post this potential definition, which maybe it's similar to what John had mentioned for patent quality. But I want to propose this. So a patent is of high quality if it adheres to the legal standards of patentability. That is, it's valid. It claims a scope that matches the inventive step, so it claims the appropriate scope. It could be broad, it could be narrow, depending on what the invention is. And of course, there's some tension between 1 and 2, right? There's some tension between validity and scope in the sense that, in a practical sense, the applicant may want to intentionally narrow scope to make it more likely that it's valid. Or they may be more willing to claim a scope that goes beyond that and risk some invalidity in order to be able to capture a little bit more market value. But there's maybe some tension between these two if we don't have perfect information, because it's not just if the patent is granted, but what is granted. And there's always going to be a tension between those two. You can claim less and have a higher probability that it's granted and higher probability of validity. But number 3, I want to add this feature. It should clearly articulate 1 and 2, right? So any patent should clearly communicate, disclose, right, what the scope is, what the invention is, and it should be very clear that this patent is valid. And we tend to think of validity as binary. It's either valid or it's not. It's either granted or it's not. But I think we need to get beyond that, right? There is a FTC standard, the person having ordinary skill in the art, and maybe that's the right level for patentability, but that's a pass-fail. And anyone who has taught or been a student knows that there's a difference between passing and getting an A. So it's okay to have patents passing, but what can we do to think about not necessarily changing the standards, but what can we think about changing the incentives to make sure that we're getting A papers out there and not C papers, A patents and not passing patents, because we can always improve that disclosure. We can always improve the certainty around the property right. And that's where I think patent quality really comes in. We can think of something that's valid, its scope matches the inventive step, but it's even of higher quality if that's extremely clear and obvious to the marketplace. Okay, so next I want to turn to some policy levers, specifically for patent quality. Right, so there are institutional resources, and I'm thinking about this as mostly the time we spend examining, the resources we put into examination. How much time do we spend on search? How much time do we give examiners for determining the rejection or allowance? Examiner and applicant incentives are critical in this. Examiners may have incentive to do a certain quantity of production during the year, and they have incentives to do a certain quality of production during the year. How are we balancing those incentives versus quality and quantity? And how can we use things like the count system at the PTO to influence that? Applicant incentives are also critical. Applicants are influenced by the process. They may have an incentive to claim as broad a claim as they can, to see what's whittled down and what's the sort of the just acceptable to the examiner. And also they're influenced by fees, among numerous other things. But thinking about those incentives is going to be critical for thinking about patent quality. Of course, we need some sort of error correction, both pre and post-grant. So pre-grant, we want to think about both sorts of errors. We want to think of it as was something allowed when it shouldn't have been, was something rejected when it shouldn't have been. And we have certain procedures for that have changed over the years. Post-grant proceedings also are going to be a type of error correction here. And the PTAB is one of those mechanisms, but that's been newly created by the AIA, but there have been historically other methods to do that. And in thinking about incentives, I want to take a moment here as an example. If we think about opportunities for applicants to make post-grant amendments, to change the claims after the patent is issued. So it gives us just an example of how we might think about incentives here, right? So what are the pros and cons of allowing this? If we allow for these kinds of post-grant amendments, then applicants have the benefit that if there was some sort of mistake or small kind of error on their applications, that could be corrected. We can fix that, and it doesn't invalidate the patent itself. On the other hand, if we have significant opportunities for amendments post-grant, then does the applicant have the same incentive for quality at the front end? Will they put in as much effort on the patent application itself? Or would they put in more effort on the patent application if there was no possibility of amendment post-grant? So I'm not going to make a proposal here one way or the other, but I'm saying that for each of these kinds of incentives, we need to think clearly and carefully about when we're changing one part of the system, what incentives that change in the other part of the system. Technology, Right, so obviously, I was glad to hear what Commissioner Hirschfeld was saying about in their investigations looking into new search systems, investigating machine learning and other things in that, because I think that's absolutely critical, not just on the search, but even the patent, the quality of the patent document itself. And I also want to think here about technology in terms of data ingestion, right? Changing the way that we collect the applications even at the PTO to make sure that everything is text searchable, because office actions and lots of information that's in the file wrapper of the patent application is prior art. And if that's not searchable and easily identifiable to folks, then it's going to decrease our quality. There's, of course, statutory and institutional reforms that I think a lot of folks here will talk about. And of course, we have to think about how are the courts going to affect things, because from a policy standpoint, it's difficult to affect what decisions the courts are going to make without clearly changing the statute in a way that we can predict. But before rules, so oftentimes when I'm talking to lawyers like to think about rules first. How are we going to fix this? Well, let's change the rule. But economists like to think about prices. Right? Before we think about changing the rules, we can think about prices. So I want to talk about a couple examples of that. And I'm going to skip the first one that I have here. I'm just going to go to a couple sort of empirical results from various papers that I've worked on at different times to think about incentives. I'm going to focus on really just this first one. So we find that applicants respond to higher RCE fees, higher fees for sort of in-process continuations for continuing the patent prosecution and examination process. They respond to these higher fees by narrowing claims ex ante in the applications as they're filed at the PTO. There was a rules package back in, I think it was 07, 08, that was about sort of limiting the number of times an applicant could do an RCE. And there was a lot of controversy about this, and eventually the package was dropped. But as an economist, I think don't prohibit something, just price it, right? You can just price it accordingly. We don't want to prohibit smoking, but we could raise the price of cigarettes, and that's going to decrease smoking. So with RCE fees, in fact, they did raise the price of RCEs and raise the second RCE price more than the first to add escalating RCE fees. So applicants did, in fact, respond to that, according to our results anyway, by narrowing the applications when they were filed. So it's the kind of incentive that we want to be thinking carefully about in a systemic way in this, in the whole patent system, the patent examination system, as we go forward in thinking about patent quality. So I will leave it with this and say that my one clear recommendation is that Congress should allow the USPTO to continue with their fee-setting authority. So I will make that statement very clearly. Thank you.
Thank you, Alan, for both your framing presentation and the interesting empirical data. I would now like to give our other panelists an opportunity both to react to the presentations by Commissioner Hirschfeld and Professor Marco, as well as to make some opening remarks. And I would welcome your views, both on the current state of the patent quality landscape and on changes in particular relating to the institution of the AIA and subsequent judicial decisions. So with that, I think we'll go down the line. And Judge Bullock, if you'd like to give remarks, I'd ask everybody to speak for about 5 minutes.
Sure. Thank you, John. So building on what Commissioner Hirschfeld said, the Patent Trial and Appeal Board, although it had predecessor boards, was created by the America Invents Act, and as well as the post-grant proceedings were established, and so we were tasked with building something brand new. As with anything new, you know that it's not going to be perfect when it is first formed, and so we've always had the notion that there would be a need to have iterative changes to get the proceedings scoped, balanced correctly. But the overall goal of the PTAB is to help achieve balance in the system and to make sure that we have strong, reliable, and predictable patent rights. And the PTAB is a part of that, it fits into the larger PTO. We're all part of the same agency. We all have the same interest in strong, predictable, and reliable patent rights. And so I'd like to note that under Director Iancu, the PTAB has been taking many steps already to ensure this and to make strides towards achieving this balance. You have probably noticed, and it was mentioned, that we have come out with a claim construction final rule. It goes into effect November 13th of this year, and it's going to achieve greater harmonization with the federal courts and the ITC, and it'll lead to greater certainty and predictability in the overall patent system. The director has also mentioned that we are working on motions to amend in the trials and looking to make motions to amend more effective. We also have recently issued new operating procedures. We issued a standard operating procedure that really gives greater transparency to how the PTAB had already been paneling cases, but it also is increasing transparency by notifying parties if there is a panel change after the panel has already been publicly disclosed. So we'll enhance transparency in that manner. We've also have another standard operating procedure that changes the way that the PTAB does its precedential opinions. It now has established a precedential opinion panel, and 2 of the 3 members are here on this panel. So Commissioner for Patents, the Chief Judge of the PTAB, and Director Iancu are the 3 members of that panel who will make precedential opinions for the PTAB that will bind the PTAB and lead to greater certainty and predictability. And then finally, I'd just like to add that we have updated our trial practice guide, and we anticipate that there will be another update to reflect other developments in the law. So thank you for the opportunity to give some opening remarks.
Thank you, Judge Bullock. Professor Riley?
Thank you. With my time in the opening remarks, I'd like to make 2 points related to the PTAB. The emergence of the PTAB is what I think is the most significant trend in patent quality in recent years. The first point is that we frequently describe the PTAB, I'm using the PTAB as a general reference to the various procedures created by the AIA. We generally think of the PTAB's function as correcting errors in patent examination. That is that patents that shouldn't have been issued if the patent office was doing the maximum effective job. There were errors, inevitable, there's going to be errors, and the PTAB is there to correct them. But I think we can think of the PTAB's role slightly differently. And that is that the PTAB reflects the dynamic nature of patent quality. We often think of patent quality as being static. That is, at the time the patent issues, a patent has some level of quality, however we're defining that, and that quality remains the same over time. But in reality, patent quality is dynamic. Patent quality can change over time, probably more so in some industries than others, based on the actions of the patentee and probably actions of the accused infringers too, as they interact with the patent. Patent rights are malleable. Patent rights can be changed over time. Patent claims can be kind of stretched, shifted, et cetera, as patentees encounter changes in the technological market and changes in the competitive market conditions. And so over time, the patent rights can shift. Patent claims can shift in terms of their coverage and in terms of their predictability, both because of the inherent difficulties in translating inventions into words, but then also because of our patent doctrines that allow this type of malleability of patent rights. So when we think of patent rights as malleable, we can see how patent quality can change over time. Most obviously, scope can change over time as a patentee attempt to stretch their patent to capture changing technological conditions and changing market conditions. But also the likelihood, the enforceability in terms of complying with the statutory conditions of patentability, which is directly connected to scope. And then last, also in terms of certainty. The farther the patent is asserted away from the disclosed embodiments, the harder it is to predict the exact coverage of a patent. So if we think of patent quality as being dynamic, then we can see another way of describing the role of the PTAB. And that is, it gives the Patent Office the opportunity to reconsider its patent grant in light of how the patentee is using the patent in response to changing market and technological conditions. It essentially allows the Patent Office to ask the question, would we have granted this patent if we knew this was the coverage that the patentee was going to seek with that patent? The second point I want to make about the PTAB is that the PTAB is largely recognized as having had a significant impact in terms of invalidating patents. And the debate in the patent community is largely whether that impact in terms of invalidating patents is ultimately good, positive, or negative for the patent system. But I think there's another question there, and that question is why? Why is it that the PTAB has been so impactful in terms of invalidating patents? To the extent that this question is addressed, it's normally addressed in comparison to litigation. Why is the PTAB more impactful in terms of invalidating patents than litigation? And therefore, the natural focus is on differences between the PTAB and litigation, primarily the burden of proof, and up until recently, or up until I think it's November, the claim construction the difference in claim construction standard. But neither of these, I don't think, are fully persuasive reasons for why the PTAB has been so impactful, because they were equally true of the reexamination procedures that pre-existed the America Invents Act. So then the question, I think, the better way of focusing on why the PTAB has been so impactful is to focus on what's different about the post-AIA procedures as compared to re-exam. And I see four major ones. One is the difficulty in getting amendments in the post-AIA procedures, which the Chief Judge spoke about. Though I question whether amendments is really driving the difference in impact. I think there's reasons to doubt that, and that can be discussed more. The next is the effectiveness of threshold screening. The PTAB denies about over 25% of petitions it receives, compared to less than 10% in ex parte reexamination. The third is increased adversarialness. And the fourth is increased expertise in the decision makers. The decision makers now are experts in both poles of the patent system, the patent law and the technology. And the final point I'd make is that these last three explanations, effective threshold screening, adversarialness, and expertise, are normally seen as positive values in institutional design, which I would think is at least informative of how we evaluate whether the impact of the PTAB has been positive or negative.
Great. Thank you. Professor Vischenbach?
Thank you. Good morning. I would like to focus my remarks today on two features of the Patent Trial and Appeal Board as well, and like Professor Riley, say a few words about the comparison of the PTAB as a source of error correction with respect to the courts. So one of those two features is the intended purpose of the PTAB as a substitute for the federal courts in patent error correction, and the other is the current moment of institutional maturity that the PTAB has now reached, and what is the best way to put that moment to use. So when it comes to court agency substitution, I think the PTAB represents a challenge that in some ways simply cannot be avoided. We began from the premise, and I'm perfectly satisfied to begin from the premise, that if we had continued to rely on the courts alone, it would be too hard, it would have been too hard, to revoke poor quality patents. And so we had to make it easier to revoke poor quality patents. But making it easier to revoke poor quality patents necessarily meant that we had to make it easier to revoke all patents. After all, if we knew which patents were poor quality to begin with, PTAB review would be unnecessary. And so now we have administrative review that deliberately departs from judicial process in important ways. And some of these departures are, I think, well advised, at least in principle. For example, more lenient standing rules means that more of the people who are subject to the exclusionary power of a patent, which of course is all of us, can hold that power accountable. It used to be you had to have Article 3 standing to get into court. Now, as I'm fond of telling my patent law students, anybody with $30,000 and a dream in their heart can go into the PTAB and challenge a patent they think is problematic. Another example is that relying on technically trained administrative patent law judges rather than lay judges or juries in federal court make it more likely that the relevant scientific detail that bears on a patent's validity will not be obscured or distorted. Right? So these features take aim at who can challenge a patent and who gets to decide. And they don't affect the substantive content of a patent's validity. So to that extent, they don't compromise the legitimate value of a properly issued patent. They go after the poorly issued ones, but generally tend to leave the poorly issued ones alone. Other departures from judicial process, I think, are somewhat more questionable. And these include discarding the presumption of validity, failing to require invalidity to be proven by clear and convincing evidence, which the Supreme Court as recently as 2011 told us had to be clear and convincing. And then, of course, until quite recently, the divergent claim construction standards that were used as between the courts and the PTAB were another source of inconsistency. Now, I think I would agree that inconsistency as such is not necessarily bad to the extent that the courts were getting it wrong, and therefore the agency should reach the inconsistent and now correct outcome. But these procedural differences that bear on the sort of substantive content of validity, I think, are something that undermine all patents indiscriminately, at least somewhat indiscriminately, not just poor quality patents. And so as a result, the sum of these desirable and undesirable attributes is that the PTAB until now has largely been a substitute of mixed quality when it comes to improving on PTAB patent error correction. Now, it's fair to say, I think, that only some of these choices were made by the USPTO itself, and a number of them were made by Congress in the statute. And so to be clear, what I'm referring to is the wisdom of the policy choices themselves, not who makes the decision or who should be held to account. The USPTO, for example, has changed course on claim construction and is in the process of reconsidering other doctrinal issues, and I think it's to be commended for that. The second point I want to make is just a brief word about the growth of the PTAB as an institution. At the outset, the Supreme Court and the Federal Circuit, early in the days of the PTAB, I think gave the USPTO fairly wide latitude, particularly when it came to deference and discretion in the PTAB. For example, the non-appealability of PTAB institution decisions could have been limited to just forbidding interlocutory review, but the Supreme Court in the Quozo case read it to extend through final judgment, gave the PTAB a lot more power vis-a-vis the Federal Circuit's power to review it. The USPTO's power to intervene in appeals could have been limited by Article 3 standing and other doctrinal rules, but that power, too, was read quite broadly by the Federal Circuit in the Knowles Electronics case. More recently, however, the courts have started to retrench a little bit, and they've started to constrain some of the USPTO's more expansive positions. For example, the en banc Federal Circuit held this year in Wi-Fi 1 that enforcement of the one-year time bar, which had previously been held unreviewable, is subject to judicial review after all. And of course, the Supreme Court held this year in SAS Institute that the PTAB has the power to institute or deny petitions in full, but cannot cherry pick some arguments and reject others. So I think these recent limits, more recent limits that the courts have imposed suggest that the courts see the PTAB as a more fully mature institution that doesn't need more latitude any longer to get itself up and running. And that maturity makes this a particular valuable occasion, in my view, to sort of engage in some reflection and reform. So as our discussion unfolds, I look forward to exploring these themes further, and in particular, sharing some empirical results about how the PTAB has been fulfilling its intended purpose. I want to commend the Federal Trade Commission for convening these hearings, and I look forward to our conversation. Thank you.
Thank you. Professor Wasserman?
Yes, so thank you. I would like to use my time today to talk about two features that are reforms that I would like to see in order, what I think would help increase patent quality. And so we've had a lot of discussion about patent quality for a while, right, on the quality of patents being issued by the Patent Office, but we've actually had little compelling empirical evidence to put forth that there's any feature of the system that's inducing the agency or causing the agency to issue low-quality patents. And this is a problem, right, because when we have policymakers are trying to improve patent quality, we're largely trying to do this in the dark. We're not sure which features we should be focusing on that would result in an improvement. So I'm hoping that this is starting to change, right? In the past few years, we've seen scholars in the U.S. patent system publish a series of empirical studies on the administrative process by which patents are obtained. After theorizing how certain features of the agency may incentivize or bias it towards allowing patents, these studies have used a range of sophisticated empirical techniques designed to show a causal connection between those agencies' features and its granting practices. So pulling on the scholarship in part is work of myself and Michael Fricks, I want to focus on two reforms. So first, I would love to see the Patent Office consider changing its fee structure, right? The agency is entirely funded through user fees, but the overwhelming majority of its costs are attributed to reviewing and examining applications. The agency charges applicants fees to help cover those expenses. However, those fees fail to cover even half of the agency's examination costs. And to make up for this deficiency, the agency relies heavily on two additional fees that are only collected in the event that a patent is granted. And this is the issuance fee, right, that's paid at the time of allowance, and renewal fees that are paid over the lifetime of an issued patent, so it remains enforceable. So one immediate concern of this back-end fee structure is that it creates a risk that the agency's fee income will fail to cover its examination expenses. So unexpected dips in renewal fees, for instance, right, is going to result in a budgetary shortfall for the agency. And an equally troubling concern, I think, of this back-end fee schedule is that if the agency finds itself in some financial strain, they could attempt to increase revenue by granting additional patents. And there's some empirical evidence to suggest that these concerns are validated. When the agency is lacking or is financially strained, they may be granting additional patents as a result. Second, I also want to suggest that I'd love to see the Patent and Trademark Office increase the time allocations it gives to patent examiners, right? Right now, examiners have only on average 19 hours to review applications, and because applications come in presumed to be legally valid, right? If an examiner doesn't have enough time to do a sufficient search and who fails to explicitly set forth reasons for why the application is rejected, they must grant the patent, right? So if examiners aren't given sufficient time to do their job, they may be allowing patents that they otherwise would have rejected. And again, there's recent empirical evidence that validates these concerns and suggests that the time allocations are binding on examiners and maybe inducing them to grant patents of low quality. But I want to note, harkening back in part to what Professor Marcos suggested, that even in light of this, there's open questions about whether we should increase time allocations, right? Because there's another institutional body, the courts, that can also remove invalid patents from the system. And there, I think, has been a number of scholars who've made this argument, but perhaps most famously by Mark Limley, who argued that because so few patents are litigated or licensed, it's better to rely upon litigation to make detailed validity determinations in those rare instances, rather than increasing resources across all at the Patent Office for all applications. And he supported his thesis with a cost-benefit analysis, where he concluded the cost of associating doubling time allocations outweigh the benefits gained by resulting in the decrease the number of invalid patents the Patent Office would issue. So Michael Frakes and I have a recent article that has revisited this issue, where we're employing new and rich sources of data along with sophisticated empirical techniques to form novel empirically driven estimates of some of the relationships that Limley had to assume in his paper. And armed with these, we actually come to the opposite conclusion, right? That we would be better off, right, increasing the time allocations at the Patent Office than relying on ex post litigation to weed out patents. I think that's, my time's up.
Great. Thank you. And I'd like to thank all of our panelists for their opening remarks. Now I'd like to shift into some questions. And again, I invite our audience to submit questions. Our colleagues are passing around cards to take them in writing. So the first question I'll ask builds upon the subject of the PTAB, which I believe everybody has raised in their opening remarks. And my first question is, of course, that the AIA has established both the inter partes review as well as post-grant review proceedings conducted by the PTAB as a replacement for the prior reexamination proceedings. And what does the evidence say regarding the effect of the PTAB in practice? Perhaps, Sarab, if you could start, and if everybody else, feel free to join in afterwards.
So I think the place to begin is the sort of baseline of federal court litigation. And we know, for example, that the procedural structure, the statutory structure of the PTAB petitions, and they sort of vary from IPR to CBM and so forth. To the extent that the PTAB is supposed to be a substitute for the courts, it's interesting first and foremost to see where are the petitioners who seek to challenge a patent in the PTAB, where are those folks coming from? And in recent research with my colleagues, particularly Artie Rai at Duke Law School, what we found is that the majority, 70% of petitioners in the PTAB have previously been sued on the patent that they now challenge. They come to the PTAB in a sort of defensive posture to try and have it out over the validity of the patent in an expert tribunal rather than staying in a court where a judge or a jury might be the one to decide. That means that a substantial minority, 30%, are preemptively striking either because they see the patent as a potential threat by their own screening and vetting, or because other rivals in the market have been sued and they think, well, we might be next, so let's strike first. So that being the case, it's interesting next to look, I think, at what the behavior of the courts is once that petition is filed. Because if the PTAB is simply one more place to fight, it's not a substitute at all, right? At that point, we're engaging in duplication, which is almost certainly going to be wasteful, and particularly if the forum where this should be playing out is the more expert, cheaper, faster, more accurate forum, the PTAB. So to look at the rate at which stays are granted in the courts, the figures vary. They're as low as 40% in the Eastern District of Texas, for example, according to one recent study, or as high as in the 70% range in the Northern District of California. That variation is itself troubling. I'm not sort of purporting to take a stand on what the right rate of stays is, but surely the variability suggests that that the degree to which the PTAB is actually serving as a substitute for the courts needs to be a little more precise. And I think the reason for that variation, at least one substantial reason, is something that the Supreme Court has only recently stepped in to fix, and that was partial institution. So in a paper that I now have coming out in the Iowa Law Review, I find that although the rate at which cases of partial institution were going down at the PTAB and have been going down since almost the beginning. They began as almost the large plurality of cases. Now they only account for something like 18%, less than a fifth of all the cases that go to the PTAB are partially instituted upon as of the SAS Institute decision. 50%. of all of the claim ground pairs, the sort of real workload of adjudicating a petition that comes to the PTAB's door is granted, and the other 50% is left out. Some of that is full institution, and some of that is full denial, and the rest is made up for by partial institution and partial denial of the same petition. So that 50-50 split has been remarkably stable. It's been persistent since almost the beginning of the PTAB. And what that means is that by engaging in partial institution, the PTAB, whether advertently or inadvertently, was muddying up the signal that it would send to the federal courts regarding how much valuable information it would really provide to the courts regarding a patent's validity. Now that partial institution is off the table, I think the signal we are granting or we are denying review will be much sharper. In both directions. And I think that's a salutary trend that will help courts make more informed judgments about when to stay their hand. And that institutional structure will go, I think it will do much to help the PTAB fulfill its intended role as a substitute for the courts.
Thank you. Would anybody else like to chime in?
Let me make just a few points, and yes, as was observed, there does seem to be a large overlap between the district courts and the petitions in the PTAB. I would just add that empirically, in talking to some district court judges after the SAS decision, they seem to be much more inclined to stay, as well as the impending claim construction rule where there will be fewer differences. It seems to have helped some of them to decide to stay their cases. Again, this is just in conversations. The other thing that I think I would just like to mention briefly with regarding the PTAB procedures replacing re-exam is just to note that the inter-parties review replaced inter-parties re-exam. Ex parte re-exam is still conducted at the PTO, and so there is still that proceeding, but that the various AIA trials were meant to address some of the shortcomings of the ex parte re-exam process, which could take considerably longer, so there are now statutory deadlines. There was an internal appeal to the former Board of Patent Appeals and Interferences that added some time to final resolution. So there have been a few things that were structurally changed in the inter-parties review from inter-parties re-exam.
One point I'd like to make is that when we evaluate the effect of the PTAB, and particularly the question of balance that the Chief Judge raised earlier, we frequently see kind of very shocking numbers in terms of invalidation, particularly those pushed by a certain point of view. And I think it's important not to ignore the effectiveness of the threshold screening. So using the PTO's most recent number, or I think most recent numbers, and doing some back of the envelope calculations, when I considered all decisions other than all claims confirmed, I treated all claims confirmed or no claims invalidated and petition denied as being favorable to the patentee, and treated all other outcomes as being adverse to the patentee, so that includes settlements and things like that may not actually be adverse to the patentee. What we see is more of like somewhere around a 60-40 split in terms of 60% of decisions being adverse to the patentee and 40% being favorable to the patentee. And certainly, I mean, that is different than outcomes in litigation. Selection effects are different there as well, but it's not as perhaps shocking as some of the numbers you'll see put out there, numbers that are ignoring that so much of that a significant portion of petitions aren't even making it to the trial stage.
Yeah, and I just want to second Professor Riley's comment.
Thank you. Well, does anybody else have anything further on this point? If not, I can move on to a related question. So building on the previous question, are there any procedural or structural aspects of the PTAB that contribute to its performance, as compared to in particular, the district court litigation or the previous reexamination proceedings? And in addition, building on this, are there areas of procedure today that are creating inefficiencies or opportunities for improvement? Melissa, would you like to start?
Yes, I'd love to. So, I mean, we all know that these PTAB adjudicatory proceedings were designed to, create a faster, cheaper alternative to district court litigation. And in order to get that, they have each proceeding provides third parties with this robust, streamlined way to contest the legitimacy of an issued patent at the patent office. And I think they share a lot of features that make them legitimate alternatives to litigation, and perhaps most saliently in comparison from the previous proceedings is they take place in this adversarial court-like hearing where the parties have oral argument and discovery. But I also think it's important to keep in mind they are not civil district court litigation, And a lot of times I think some of the concerns or the angst that I hear from the patent community loses sight of that, And I think the most appropriate comparison when we're thinking about PTAB adjudication and its procedures are to other agency adjudications. And in particular, I think they fall in this idea where they have a hearing, but they're not something under administrative law, formal APA governed adjudication. There's an ACA study that's come out that's compared what are the best practices for agency adjudications of the ones like PTAB proceedings, and PTAB fares quite well. They come out of having 16 of those 20 best practices, which puts them well into the top third, I think, of the agency adjudicators. There's a couple areas that are pointed out where I think they could do more. One I would consider is doing a more robust or formal disqualification mechanism for adjudicator bias. It's my understanding they have that, but it's not as formalized as I would like to see. And another recommendation was to have some higher level consideration, but I think in part the changes they've made with how they're making determinations about precedential decisions help address that, and I thought that was a very positive move that I saw from the PTAB. So where are other areas that you could see improvement? I think one has already been touched on, which this idea with stays in district court and how much of this are we just sort of getting duplicative litigation occurring in PTAB and district court, which I don't think was the intention, and certainly cuts back on the sort of cost-effective saving side associated with PTAB litigation. Another thing that I wanted to point out, and I know the PTO is doing some on this, and I commend and would like to do more, is the feedback loop, though, that occurs with these new PTAB adjudications and patent examiners, So when you have a patent denial or an ex parte review, the patent examiner's involved in that denial before the PTAB. But in the patent grant side, if you're using one of these PTAB new post-grant proceedings, the patent examiner that issued that patent is usually not intimately involved in that litigation. You have two adversarial parties litigating. And so I think there's room, for sort of more feedback to patent examiners on sort of best practices and things that are coming out of PTAB that might also help improve patent quality. And I know the Patent Office has had some pilot programs associated with that, but I would love to see more of that implemented.
Alan, go ahead.
Yeah, I just had one thing I wanted to add in a more general sense, in that when we're evaluating sort of the impact of PTAB and the effectiveness of that, everything that all the numbers we're looking at so far, not all, the majority of the numbers that we're looking at so far are on patents that were granted before the PTAB was established. And when we look at the effect of any sort of institutional change, the effect is not going to be immediately obvious, especially in a system where the patents can, hang around for a couple of decades. So we need to, when we're evaluating the institutional change, we really want to be, in the end, looking at how the reforms affect new applications and patenting as it's happening now. That's harder, that takes more time, it requires more data, but we can look to certain experiments where we might be able to look at data and how applicants changed their claim drafting procedures after Supreme Court decisions like Alice, Myriad, Mayo, because we do see that in the data. And so the effect of PTAB on the claim drafting procedures, we can look at, but it's a little bit more of a difficult process.
Please.
Okay. I was just going to note, a few of the other maybe procedural and structural differences between the PTAB practice, re-exam practice, and district courts. Then several of these have kind of been touched on, so I'll just run through them quickly. But one is the decision maker. In district court, of course, you have a generalist Article III judge presiding over the trial there. In re-exam practice, you have an examiner with a possibility of an appeal to the PTAB. And then in the AIA trials, you have the three legally and technically trained administrative judges conducting the trial. The standards for institution are different for all of these. The PTAB AIA trials, it's either reasonable likelihood for IPRs or more likely than not for post-grant review and covered business method reviews. When inter-parties re-exam was going on post-passage of the AIA, it was also reasonable likelihood. And then, of course, substantial new question of patentability is the standard for ex parte re-exam. And district court, it's just essentially a pleading. Time for completion, of course, the AIA trials have statutory deadlines. That's had a large impact on the operation of the board, both the 3-month deadline for an institution decision after a patent owner preliminary response, and then 12 months extendable by up to 6 more months for good cause after an institution decision's made. Re-exams are no specific time limit, but they are conducted with special dispatch, and there's no time limit in the district court, but as we know, some districts pride themselves on their speed. Another aspect is, of course, discovery. The AIA trials by statute have limited discovery. They're in line with finding things that are useful and trying to eliminate expensive fishing expeditions. There was no discovery in re-exam. Of course, district court has much more fulsome discovery. Claim construction standards, we talked about briefly. The AIA trials had been conducted under broadest reasonable interpretations, shifting next month to Phillips. However, I should note that for expired patents, the construction standard has always been Phillips. In fact, the Phillips standard was used in re-exam for expired patents. Re-exam will continue to use broadest reasonable. Of course, district court uses the Phillips standard. Amendments, there is a more limited right to amend by statute in the AIA trials. Re-exams, there were amendments before final, entered as of right, and then there was an after final practice. And also you had an examiner search as part of the re-exam amendment practice. Of course, in district court, there's no amendment. And just, I think, areas of potential improvement, really the only thing I would add is just to say that the PTAB and the Patents Organization are, in fact, actively collaborating and sharing information to feed that information back from the AIA trials to the patent examiners. And maybe I'll see if Drew wanted to add anything.
Thank you, Scott. I was just going to jump in on the same point. So, first of all, I agree with Professor Wasserman that the more feedback we can give from PTAB to examiners is important. And I think as the last few years have rolled on, we have been certainly making progress in this regard. First, every examiner now has access in their regular desktop to related U.S. or anything that's in an appeal. They get those cases if they have a trial. So in other words, I'm sorry, I'm not being clear on that. So an examiner who has a related case that's in a PTAB proceeding, they will be able to have access to all of those papers and documents so that they can review that. We also have in each and examiners are given time on our production system to review those papers as well. So I think that is a huge step. And then we have in each area of the technology centers, we have people who go through the PTAB decisions looking for trends. Are these a one-off decision that there's not a teaching point, or are there trends, or are there learning points that we can get to feedback to examiners, and we have staff doing that. And I know Scott mentioned the Presidential Opinion Panel. I believe that will be very instrumental in getting the Patent Operations Division under me and the PTAB under Scott together on the same page, as we will both be on those panels with, of course, the Undersecretary of Commerce. And I think that is a very helpful step, and that is very recent. And then we've also created a new position, which we've never had before, which is actually being currently occupied by our previous Chief Judge, David Rushke, whose responsibility is to be working on issues of collaboration between patents and the PTAB. So these are all steps, I think, that are taking us in the right direction.
I just want to make one additional point on the amendments question. I think one of the things I know the Commission does is investigate issues and try to develop information. And I think one question is the role of amendments in post-issuance proceedings. The most common outcome of reexamination was amended claims, and that's a very stark difference from the AIA proceedings. And I think it would be, when you look at some of the reports from re-exam, there were kind of, from practitioners, there was a sense that the amendments in re-exam weren't that significant a lot of the time, that they were minor, that they could actually be advantageous to the patent owner. So it's not clear to what extent those were doing a lot of work in explaining the difference in invalidation rates between re-exam and PTAB. But we need to know more about what the amendments were like in re-exam. And then on the other hand, you see there's, according to the PTO's numbers, there's just not a lot of requests for amendments in the AIA procedures. Of course, that's potentially circular because people don't make requests because they'll think they'll be denied. But it would be interesting to know to what extent amendments that a patentee would want to make, of course, they might not want to make an amendment because it would eliminate their ability to prove infringement, but to what extent amendments patentees would want to make would save the validity of patents in AIA procedures.
If I could sort of touch on something that Professor Marco pointed out, and then make a related point. So the change in regime, AIA was widely touted, and I think correctly touted, as the most substantial change to the patent law in over half a century, and that's right. But it's not as if the patent system, even in the decade or two preceding the AIA, had not suffered substantial discrete shocks along the way. And one sort of interesting measure of that is that inter partes review, being retroactively applicable to patents that were issued prior to AIA being enacted, at the outset, 100% of IPR petitions were on patents that issued before AIA went into effect. So retroactivity is almost sort of tautological in that sense. But it's worth pointing out, too, that 30% at the outset of the patents that were challenged in inter partes review, and that number's been going down, but 30% were pre-inter partes re-exam patents. So these are patents issued prior to the American Inventors Protection Act, which passed in 1999 and went into effect in 2001, right? So what happened in that time? Well, a number of important Federal Circuit decisions came down, and certainly the Supreme Court had already by that point begun what we now know was a very substantial tetralogy of cases on Section 101 eligibility. So when we talk about the AIA and particularly PTAB as a system for correcting errors in patent examination due to resource constraints, inadequate search, improper application of law to fact, and these sorts of things, that is distinct in kind from the problem of the law changing under our feet, which happens commensurately and sort of correspondingly highly. And as a result of that, we need to be able to disentangle them if we're going to engage in the kind of evaluation that a substantial reform to PTAB practice would really require. And I think in order to do that, it's worth pointing out some of the data that I've already begun to use. The USPTO has put out a large and very rich data set on office actions and the grounds on which patent applications were rejected and the prior art that was cited and all these sorts of things. So by applying that data set to review the set of patents that are being challenged in litigation, in inter partes review or post-grant review, which is a project I'm already undertaking. Those sorts of more specific questions can help us disentangle whether it's really examination process that was to blame for a patent that was issued and is now being invalidated, or simply a change in the law, which the Patent Office can't do very much about at all, because it's the courts who are ultimately responsible for that. So that's the point about changes in regime. Now, the related point is, I think, and this goes back to the original question that John posed about structural aspects of the PTAB. I think deference and discretion in the PTAB, it's an area that's gotten some study, and I think it merits further study, because the Patent Office, historically, of course, did not get substantive rulemaking authority, was not on the receiving end of Chevron deference like most other agencies in the modern administrative state, and there are, of course, reasons for that. But to the extent that the PTAB now engages in what might be termed formal adjudication, right? Yeah, formal enough. I think the fact that we still don't see a lot of oxygen going to the issue of Chevron deference is well summarized by my co-author Artie Rai in a paper from a couple years ago that the PTO could ask for Chevron deference and is choosing not to, and that's fine. But as I've discussed in recent scholarship of my own, it's not as if they're not asking for discretion or trying to immunize themselves from interference from the courts, because there is, of course, this non-appealability provision. And Quozo at the outset was the opening salvo. We think that this isn't just a ban on interlocutory review, it extends all the way through final judgment. That was contested, and the Supreme Court told us the answer. After that, there was the question of partial institution. And along the way, there was the question of the one-year time bar, right? So at each step along the way, further and further expansive views of what non-appealability covers and what non-appealability immunizes has been, I think, an area that has not gotten a lot of attention. And ultimately, if the agency enjoys non-appealable discretion to do whatever it wants, then functionally, I don't see any difference between that and Chevron deference, because they're still doing what they're doing without a lot of interference from the courts. And that can be good or bad, but it needs to be sort of better theorized and better understood.
Great. Thank you. I think in the interest of time, we're going to move on to a few other subjects. So my colleague, Elizabeth.
So a few of you mentioned the new claim construction rule, and I want to shift gears a bit and talk about the interpretation of granted claims. We've had several Supreme Court decisions in recent years, the 2014 Nautilus decision, the Teva decision in 2015. And so I'd like to hear the panelists' views on what the implications of these changes are, both in district courts and in PTAB proceedings. Maybe Professor Riley can start us off.
Sure. So Nautilus, which made it easier to prove indefiniteness of a patent claim, and Teva, which gave deference to district court findings on claim construction to the extent they were factual findings, the factual underpinnings of claim construction. They were widely acclaimed as significant decisions for patent clarity and patent quality at the time. And by most reports, they've had minimal impact. And the best conclusion is that they really haven't had that substantial of an impact. And it's easy to blame that on one of the two punching bags of the patent system, either the Supreme Court or the Federal Circuit. The Supreme Court, in both cases, took a middle ground approach. It clearly rejected the Federal Circuit's approach, but it didn't go to the opposite extreme. Instead, it took a middle road where there has to be reasonable certainty for a claim to be definite, and there'd be deference, but only for factual findings. And both of these standards are relatively unclear and leave a lot of room for implementation. And the evidence suggests that the Federal Circuit has largely used that room for implementation to change some of the language, change at the margins, but largely follow its prior approaches before each of those decisions. But I think it's important to go beyond just the easy targets of blaming the Supreme Court or the Federal Circuit, because I don't think either decision was well positioned to have that significant impact on patent clarity or patent quality. Teva is the easiest example. Teva, despite its this claim construction standard, despite its popularity in the patent community, was never going to do that much for patent quality or patent certainty. And the reason for that is TEVA only affects what I'll call ex post certainty. It only affects the likelihood that the claim construction will remain after the claim has been construed in litigation. TEVA says it makes it more likely that that will stay throughout the remainder of litigation. And that can be important. That can potentially reduce litigation costs. It can encourage settlements, et cetera. But TEVA was never going to have any effect on ex ante predictability of claim scope. It never was going to have any effect on how a party before litigation or before potentially infringing activities could evaluate the scope of the patent claim. And TEVA wasn't directly about our method of claim construction either, so it wasn't really going to affect breadth. Nautilus, one of the problems with Nautilus is the court tried to resolve it, and the issue was posed for the court, the indefiniteness issue separate from claim construction. And you can't really decide indefiniteness without deciding claim construction. Words in patent claims, like any other words, have no meaning without context. They are neither definite nor indefinite in the abstract. They only take on meaning from context, whether that context be extrinsic evidence of the use in the field or whether it be intrinsic evidence in the document itself. And patent and claim construction is the process of giving meaning from context. And so trying to resolve the definiteness of a patent without also addressing how claims are construed, how claims are given meaning from context, was always going to be a losing or at least minimally impactful proposition in my view.
So if I may, I have a question for Professor Riley. So I'm not sure that I understand or agree, it might be one or the other, your point about ex post certainty, because it's certainly the case that if a patent has been construed, or the claims of a patent have been construed, and if TEVA had gone the other way, if it were de novo review, right? It goes up to the Federal Circuit. They lay down what the claims of that patent mean. If that's litigated again, there is ex ante certainty in a dynamic sense. The first time it's construed, it's not. Now, the fact that TEVA went the other way, I think, has a substantial effect because the court was much more concerned about vertical certainty. It's less likely to change course from trial court to appeal court, and not very much concerned at all, it seems, with horizontal certainty, because inconsistent claim constructions in two different district courts on the same patent claim term are likely to persist and not be overturned, even though they conflict with each other. On appeal, they're going to get that clear error deference. So it seems to me that there is an effect on ex post certainty as well as ex ante certainty in the dynamic sense. Would you agree with that?
I'd agree that yes, once a patent has been construed and gone to the Federal Circuit, that will impose presumably some level of predictability of claim scope for future activities. I was focusing on before a patent is litigated. If I am a party trying to decide whether I have the freedom to operate in this area and the patent hasn't been litigated yet, which I think is the most common situation, if I'm trying to evaluate the freedom to operate, I need predictable rules of claim construction. We always think of claim construction as a litigation thing, but everyone in the patent system has to engage in claim construction, right, to know what the scope of coverage is. And if we have predictable rules of claim construction, then it's more likely that my evaluation ex ante will be the same as the court ex post in litigation. And to me, I think that's much more significant than predictability once a court has construed the claims, because A, very few patents are litigated, B, a lot of patents are litigated patents are settled without a claim construction, and then C, a lot of patents that receive a claim construction, of those, only a small number go to the Federal Circuit on appeal, where TEVA would ever have an effect.
Gotcha.
Great. Well, again, in the interest of time, we'll move on to another question, which is that the AIA authorizes the director of the USPTO to adjust or set patent fees. And how has the Patent Office used its authority, and how has this influenced incentives to apply for and maintain patent rights? Actually, Commissioner Hirschfeld, I was wondering if you could speak to that first, then perhaps Professor Marco.
Sure, I'd be happy to. Thank you for the question. So the USPTO, as was just mentioned, was given fee-setting authority, and the irony now is we are currently in a fee-setting making process, which I will explain in a minute, and we're very close to, but not having yet, I believe, an extension to our fee-setting authority. It actually did lapse, and the House and the Senate have passed a bill to extend that, and I believe that is over to the President for signature as we speak. So how have we used this in the past since the AIA? We have used this to set fees where needed. Historically, before the AIA, fees would change, but they would usually be cost of living changes. What the AIA has enabled us to do is put fees to how they should be used most effectively. So we still are cost recovery in the aggregate, but we don't necessarily need to be cost recovery for any particular item. So if we want to make some changes, we will. As I mentioned, we are in a fee-setting process right now, which of course started with our authority. And one I'd like to mention, because it touches on a point earlier, and this is a segue to incentives, is in the fee-setting process now, we are looking at, for the first time, having a surcharge for documents that are not filed in what we Doc X. And that is intentionally an incentive so that people will start filing in Doc X, giving us the ability to make office actions and all documents text searchable, which was a comment that was raised earlier. So it is fees like that we could change. I also, if you take a look at some of the fees we are proposing, we actually are in the slightly moving some of the fees from the back-end cost up front, although which is a point Professor Wasserman raised earlier, and I did want to address that in the bigger picture as well, since we're talking about fees. The structure to the fees at the USPTO is intentionally that the upfront costs of fees are very low compared to the back-end costs. The reasons for that are so that you're incentivizing people to join into the patent system and seek patent protection. And then those who are successful, i.e. getting the patents and successfully marketing those patents so they want to pay their maintenance fees, subsidize the cost of all. That's been the structure for as long as I'm aware of the patent fees themselves. So I agree with Professor Wasserman that there is a balance that is important to the front end and the back end fees, and it's something we're always discussing at USPTO. But the reason behind that, again, is so that the successful people are subsidizing the rest. The comment about USPTO having an allowance rate based on money, quite frankly, as I do disagree with that. I've been at the USPTO 24 years as an examiner and virtually have held every management position. Not once have I uttered or seen an instruction to any examiner to raise allowance rates for any fee purposes. We want examiners making the decisions for the right reasons. The maintenance fees start at 3.5 years, and then there's one at 7.5 years and 11 years. If we needed fees down the road, we would engage in the fee setting approach, which would be the most effective way to raise fees if needed, as opposed to changing the allowance rate. Again, that we want people to make the decisions for the right reasons. Last point on the fees is, since we are in a process, this process is a long fee setting process. We're actually setting the fees now for 2021. Our public advisory committee has had a public hearing on the fees. They will be issuing a report on their views of our proposed fee setting. Then the next step to that would be USPTO receives that report and makes a notice of proposed rulemaking with a comment period so that all of you can weigh in and everybody can weigh in on our proposed fees. We would, of course, take those into consideration, and then there will be a final rule upon the issuance, and that is set for January 2021 at this point.
And if I could make just one comment, just to follow Commissioner Hirschfeld, for the PTAB AIA trial fees, those are set to recover the costs using the best available data. Of course, when we first stood up the trials, there was no data. We used estimates based on other proceedings at the office, and as data has become available, we've used the data as best available to set it at a reasonable cost recovery level. So I just wanted to add that for the AIA trials.
Yeah, and so let me add just a couple comments about the fee setting. So, and having been involved in it, I guess 1.5 times, it is a long process, and for an economist certainly that was a frustrating process because we just want to change the fees, right? So, and one of the hard parts about it is that the fees, because it's a long process and because they haven't been changed very frequently, it means there's not a lot of data on how applicants can respond to those fees. And this puts the PTO in kind of a bind because it says, well, we need to change the fees, but if we wanted to sort of incentivize some applicant behavior or other behavior, it's hard to know what the response is going to be. So because we don't have the evidence, it's hard to say what the response of those is going to be, and so it's hard to know how to change them. So I would say 2 things. So I'm glad to hear about the DocX. I think that's fantastic. But some people do argue about the office using fees to change or incentivize applicant behavior, and I think this is something that we just need to get past for this reason. The purpose of the patent system is to create patent rights, right, that we're giving for a purpose, for progress in the useful arts, right? It's for progress. So the design of the patent system is for that purpose, and so if the fees help us to accomplish that purpose, right? The patents themselves change behavior. They're designed to incentivize behavior, right? So the fees themselves are just part of that system. So they are used to change behavior. So one recommendation that I would make in order to get more data is something that government agencies have been doing a little bit more in the last decade or so, is through experiments, right? There are some possibilities in certain areas where one may be able to do experiments on, let's say, maintenance fees. So you're granted a patent and it says, congratulations, you've been given a 90% discount on all your patent fees. And by looking at how applicants respond, for a small portion of grants, we could give a discount of some amount. And to see how applicants respond to that can tell us more about the fees without having a huge impact on revenue, so long as the PTO could have authority to actually run those sorts of experiments.
So can I just say a few words too that I want to follow up? So I think all of this is great, and I definitely support the Patent and Trademark Office extension and their fee-setting authority and utilizing fees to help adjust applicant incentives. I think that I agree with that as well. I just think it's important to keep in mind, right, when we think of the fee structure, it's not just applicant incentives, but agency incentives as well that can be created by, that are created by the fee structure. And so I agree, there's wonderful reasons to keep renewal fees, and we should definitely keep them from a social welfare perspective, but there are other agencies, for example, the European Patent Office, right, that has renewal fees, but they are not themselves funded off of those renewal fees. Some of those renewal fees go to the national patent offices, so there are ways to sort of decouple the incentives that may be set up from agencies by the fee structure and allow them to then just sort of utilize it to maximize applicant incentives.
Thank you. Unfortunately, looking at the clock, I realized that we were about at the end of our hour, and this has been a fascinating discussion that could likely continue for days. I would like now to give each of our panelists an opportunity to make some final statements. I'd ask you keep it to a minute or two just in the interest of time, and perhaps let's go down the line. So Commissioner Hirschfeld, if you could go first, please.
Sure, thank you very much. Well, and again, thank you to the FTC for having this hearing and including us at USPTO. I will just reiterate some of the points that I tried to make earlier, that I think the Patent and Trademark Office's role is very critical. We can take a lot of steps to make sure that that the scope of patents is very clear, and those patents withstand challenges. And you'll hear the words, the phrase certainty and reliability spoken by me and my colleagues at PTO. That is our focus, to make sure that as much as we can put certainty and reliability so that when somebody gets a patent, they know they can count on it, they know it will withstand a challenge. When somebody is applying for a patent application, they understand the guidance that is going to be used by examiners to determine whether that is deserving of patent protection or not. That is our main focus and will continue to be, so that we are helping those great inventors move this country forward.
Thank you.
Yeah, thanks. So very briefly, keep fee-setting authority with the PTO. Focus on incentives and examination incentives. Examiners it's easy to count the amount of actions they do. It's easy to count the production. It's harder to identify, to estimate quality in the examination, the quality of the examination itself. But there does need to be a reward system in place that incentivizes the quality as well as quantity and allows for a trade-off between those and the examination level. That's hard to do, but it's certainly worth continuing to work on. Applicants are incentivized by fees, and I think by thinking carefully about those incentives, we can get to a place where we are incentivizing A+ patents instead of pass-fail kind of patents. So, thank you.
Thank you. So as Commissioner Hirschfeld mentioned, we are seeking balance in the system to achieve strong, reliable, predictable patent rights. As I mentioned in my opening remarks, the PTAB proceedings in particular were meant to be iterated. It was always contemplated that there would be iterations in order to achieve this balance. We've undertaken many such iterations. We're going to look forward to the input of the public and look forward to future iterations to achieve that balance. Thank you.
And speaking about the claim construction issues, I suggested Teva and Nautilus didn't have much impact on questions of patent clarity and patent quality. And I did want to flag one issue that I do think is worth addressing that would have an impact on one claim construction issue that would have an impact on patent clarity and quality. And that's a persistent split within the Federal Circuit as to the method of claim construction, whether to essentially the role of the specification, whether you start with some sort of abstract ordinary meaning in the field and then only look to the intrinsic evidence, the patent and prosecution history for express disclaimer or disavowal of clear definition, or whether you start with the specification and develop a contextual understanding from the document with limited reliance on extrinsic evidence. And Professors Wagner and Petherbridge showed empirically before Phillips that this drove most disputes on claim construction in the patent system, and importantly recreated that study several years post-Phillips to show that Phillips didn't address it. In fact, most disagreements in the Federal Circuit and most of the disagreements between the Federal Circuit and the district courts relate to that, to which of those two approaches to claim construction to take.
So I'll close simply by pointing to the sort of recalling the moment of institutional maturity that I spoke about at the beginning of my remarks. I think the way forward and the way in which this iteration that Chief Judge Bullock spoke about should proceed is something that the Patent Office has already been doing, I think, an excellent job of, and sort of two ways in which I hope that they continue doing that is to continue to publish data for use by empirical scholars and policymakers to engage in exactly the kind of rigorous examination that we would like the patent system to use. And then the other is bringing in experts into the agency, which has been going on now for the better part of this last decade through programs like the Edison Scholars, the Chief Economist Visiting Speaker Series. I think these are extraordinarily helpful uses of human capital that the Patent Office has taken, I think, very good advantage of. And these are the ways in which the agency will stay connected to, a very rich ecosystem of expertise and opinion. Thank you.
Yeah, and I want to echo a little bit of that. I think, that when we move forward with patent quality and we're looking to make changes in order to improve it to the extent possible, it's fantastic we can do so using empirical guidance and those determinations. And I think both Professor Marco's comment about experimenting would be a fantastic way to get more information on that. And then also, commend the Patent and Trademark Office, who has just released huge amounts of data that I think has really resulted in a large and growing number of scholars that are doing empirical work in this area.
Great. Thank you. And I appreciate our panelists keeping their closing remarks brief. That actually allows us perhaps 2 minutes to field one of the many wonderful questions we received from the audience. And this is actually directed to Commissioner Hirschfeld. And could you speak to the use of artificial intelligence and other resources during examination, both on their impact and also on the time that they may save examiners while they're conducting examination?
Sure. So right now, I don't think there is a significant use in practice of artificial intelligence for examiners. That being said, we have examiners and others working on artificial intelligence tools to help us potentially move forward. I actually saw a tool that was written by an examiner on her own time to make her life easier, where she could highlight text. It would go to databases and take her search areas into consideration and rank results for her and give them back. I've seen another tool that takes search data that examiners in any particular art unit work on and evaluates that data so that any subsequent examiner can put in potential search terms and get synonyms of those terms based on the particular technology they work in. And then, of course, they can rate the results of that so that it's learning for future examiners to improve from. These are all tools that are being discussed and not in use yet and are being worked on. I think the sky is absolutely the limit to this. I mentioned our request for comments that came out in September. That is, we are hoping to get additional feedback that we can, potentially more information that we can use to further enhance and accelerate our efforts to incorporate AI into the examiner search. I personally feel it's like just the perfectly ripe place for artificial intelligence, given that you have thousands and thousands, over 8,000 people doing searches. Now, they're not all doing the same technology, but doing similar searches. You can learn, having machine learning best practices and looking at, potentially years of data to be able to figure out how to move forward. The second part of the question was about time. I'm actually really happy you asked about time. I don't necessarily foresee the artificial intelligence taking time away from an examiner. Professor Wasserman touched on this earlier about the constraints of examiner time. I also agree that there are concerns about examiner time. So any efficiencies we can gain, I think, are important. It's not necessarily meaning we're going to take away time, and really, in my opinion, is likely not to take away time from examiners. The efficiencies can be put back into the system, is what I would think. On the note of time, we are evaluating examiner time, and that is something I think you will see in the coming months. I mean, the system that we're under is ripe for change, and we are looking at that now, and so that is likely to. Of course, all the tools that we have now and in the future will play into the amount of time examiners have.
Well, I think on the subject of time, it's as if our hour is up. I would hope that you could all join me in thanking our panelists and my colleague Elizabeth Gillen. I think it's been a very productive conversation and really appreciate your lending your expertise to our hearings. Thank you.
Thank you.
Thank you.
We are now going to take a break, and we'll resume at 11 o'clock.